Good afternoon, everyone. I'd like to thank you for joining us this morning for our webinar covering best practices and current topics in employment law. I'm Larry Casey, and I'm a shareholder at Davis Malm's employment practice. We will be recording today's webinar and will circulate a link to the recording, as well as the slides after the presentation. If you have any questions on the topics being discussed, feel free to submit them in the Q&A box. We will address as many questions as possible at the end of the presentation. Before we get started, I'd like to introduce you to our presenters for today's webinar. From our employment practice, we have Tamsin Kaplan, Michelle Casola, Taylor Lovejoy, and Dave Rogers. Dave also serves in the Massachusetts House of Representatives as state representative for the 24th Middlesex District, covering Arlington, Belmont, and Cambridge. We are also happy to have Allison Ahern-Philo join us from our immigration practice, and she will be providing some insights on immigration laws as they affect employment. Without further ado, I will pass the screen to Michelle and Allison, who will kick off today's program discussing good hiring practices, job postings, and applications.
Great. Thank you, Larry. Yes, I'll be, as Larry mentioned, Allison and I will be covering best practices in terms of hiring, and I'll be handling the topic from the employment law perspective, and then I'll pass it off to Allison, who will talk about it in terms of the immigration and citizenship perspective. So if we could go to the first slide, please. Great. So the first step when hiring is obviously a job posting, and it is important for the posting to be largely devoted to a description of the job, the desired skills and experience, the duties, so people are aware of, whether it may be something that they are qualified for and interested in. It's perfectly fine to describe qualities that you're looking for in terms of, a hardworking, energetic team member, or to talk about experience in terms of this is an entry-level position. Next slide, please. But what you don't want to do is include any language on the job posting suggesting that you're looking for someone of a particular gender or age or race. For example, you don't want to say things like, we're looking for a young, vibrant person, or we're, this job is perfect for someone who recently graduated college. Those can trigger issues around potential age discrimination claims if you're seen to be excluding or discouraging people who are older from applying for the position. Next slide, please. Another thing that is sort of a new hot topic in the job posting space is salary transparency. So many states and some cities even have recently passed laws requiring a job posting to include a salary range or for that information to be provided at some point during the application process prior to an offer being made. This is not yet a requirement here in Massachusetts, although there is a bill pending this session in the state legislature, so it may very well be a requirement here soon. But if you're currently hiring outside of Massachusetts, you want to make sure that you're aware of any requirements that are in place now on that issue. Next slide, please. In terms of written applications or applications that people are filling out online, there are a number of sort of categories of things not to ask, which are represented well by this this imagery. So you really want the application to be focused on the person's experience and skills so that you can assess whether they are qualified to receive an interview. What you don't want to do is ask about any of these protected categories. They are irrelevant to whether the candidate can perform the job. Next slide, please. So there are a number, like I mentioned, a number of issues you want to stay away from on the application. Age, other than you can confirm that the person is over 18. But other than that, you don't want to ask anything about, you don't want to ask date of birth, when year did you graduate college, things like that that can be used to determine someone's age. disability. You don't want to ask whether the person has a disability. However, it is permissible to ask whether the person can perform the job functions either with or without accommodations. If an applicant affirmatively discloses a disability, you haven't asked, but they sort of volunteer that information, then you likely will need to provide a reasonable accommodation during the application process. So that does trigger some responsibility on the hiring party's end to make sure that that disability is accommodated. You don't want to ask questions about gender. Don't ask for pronouns. Don't have a slot for someone to list a maiden name. A number of questions that should be avoided, even though they don't directly ask about gender. Things like, do you have kids? Do you want kids in the future? This is a demanding job. How are you going to handle childcare? Are you married? Does your spouse work? These can all be seen as sort of a proxy for asking women about how they, potentially whether they may have issues performing the job responsibilities based on their personal lives. So there's sort of a proxy for asking about gender. You also want to avoid asking about gender identity. Next slide. A few other protected categories that you want to stay away from: genetic information, national origin. So don't ask about where someone was born. Even in an interview, you really want to be careful about this in terms of small talk, like, oh, what an interesting name, where are your parents from? Or I think I hear a bit of an accent, where did you grow up? All of that can sort of, even if you're not affirmatively asking, what is your national origin? Those questions can elicit that same information, and so should be avoided. You don't want to ask anyone if they are pregnant or what their race or color is. A few other what not to ask. Criminal record information. Here in Massachusetts, we have a statute known as Ban the Box, which prohibits asking on the initial application about largely misdemeanors within the last 3 years, records that have been expunged, juvenile records, or records that arrest or detentions that didn't lead to a conviction. And that is largely applicable. There are exceptions for some industries, like the person is applying for a job in childcare or with certain financial institutions. Those questions are permissible, but for the most part are not. Following the initial application, and if you're planning to make a job offer, there is some more information that you're entitled to ask, namely about felony convictions or misdemeanor convictions from less than 3 years prior. Next slide, please. A couple of other categories to stay away from are religion and sexual orientation. Again, these are largely irrelevant to anyone's ability to perform the job, with one note that if there may be an obligation to accommodate a person's religion, but that as long as that won't impact their job duties, then that is something that really shouldn't be discussed. Job postings in Massachusetts, or I'm sorry, in the application and interviews cannot inquire as to the applicant's salary history. This is a relatively new statute that was enacted to prevent, essentially, to prevent perpetuation of lower compensation, which tended to be women and people of color, historically have been paid less than white men. And so continuing to base, a new job offer based on a past salary serves to perpetuate that. And so this statute was passed to try to avoid that and improve pay equity. So you don't want to ask someone, what is your current compensation? However, it's perfectly fine to ask, what are your salary expectations? It's just, a good way of getting to the same information, but without directly asking, what is your current compensation? Next slide, please. And in terms of what can an employer ask, and it, aside from questions about the person's experience and how they would perform the job, which should be the focus, you are permitted to inquire about someone's veteran status. You are permitted to do a credit report, although there are requirements that must be followed in terms of the Fair Credit Reporting Act. You can ask for references. There is a privilege in the law for someone to provide an honest reference, and it's not considered to be defamation. And so with that, I will pass it to Allison, who will speak about the same topic in terms of questions about citizenship.
Thanks, Michelle. Good afternoon, everyone. So another additional issue to keep in mind when posting open positions and reviewing applications is to avoid citizenship status discrimination. And on a high level, this means employers do not want to make distinctions between U.S. citizens, U.S. permanent residents, which are green card holders, and individuals on a temporary visa or temporary status when engaging with job seekers. So at the outset, the job posting, do not include restrictive language, such as U.S. citizens only, or U.S. citizens, U.S. permanent residents, or individuals with a certain type of work visa. That violates the statute. There is an exception for jobs that specifically require U.S. citizenship. There are certain government positions and even positions in the private sector that have government contracts that require U.S. citizenship. And that's an exception to this. But on the job posting, it's it's recommended that be explained a little bit. So instead of just putting U.S. citizens only, and you as the employer knowing, well, this is permissible because this is a job that does require U.S. citizenship, that verbiage should be included in the job posting to avoid any potential claims that the employer is violating this law. Next slide, please. So then, during the application review process, there are very specific questions that employers should not ask with regard to citizenship status. Examples are listed here. Basically, questions that get to the specifics of how the person is authorized to work in the United States. So directly asking, are you a U.S. citizen? Or do you have a green card? Questions on specific work authorization, like what is your authorization to work in the United States? Are you on a visa? What type of visa? And then questions beyond work authorization, such as, do you have legal status or are you legal here? Very bad, do not do. Next slide, please. And then there are questions that more open-ended employers are permitted to ask. So are you authorized to work in the United States? Do you require visa sponsorship? Do you currently require visa sponsorship to lawfully work for our company here in the US? Those questions are more open-ended. And again, they don't get to like the specific type of work authorization. If an employer asks any questions about authorization to work in the United States, it's critical to ask them of every candidate. Keep it consistent. Do not selectively ask such questions based on an inclination that the person may need a specific type of visa sponsorship. Next slide, please. And then a common question is, if visa sponsorship is required, is the employer required to sponsor the visa? The answer to that is no. And employers are not required to proceed in sponsoring a visa if the candidate says, yes, I do need visa sponsorship. And then if the candidate does say, I do need visa sponsorship, an employer may ask further questions to assess the eligibility for various types of U.S. work visas, what that application process would be like, to ensure that they can actually accept the employment and start working for the employer. Next slide, please. And then I just wanted to include some additional information and resources. The first link is the Department of Justice's Immigrant and Employee Rights page. And that actually has some good examples in the press releases of instances where employers have violated these laws, just for reference. Thank you so much. And now I will pass it off to Taylor Lovejoy. Thank you.
Good afternoon, everybody. I'm here to talk a little bit about independent contractors, specifically in Massachusetts, which is a hot button topic year in and year out, never quite seems to go away. Next slide, please. So I'm sure many of you, if not all of you who are in attendance, have heard the terms employee and independent contractor, but what do those terms really mean? As you can see on the slide before you, separating to left and right, employees on the one hand, those are your payroll workers. They're the workers that you provide benefits to. Businesses can take deductions for. There are withholding requirements for tax purposes, payments into unemployment insurance, things of that nature. And they're also covered by the wage and hour laws like the Fair Labor Standards Act and the Massachusetts Wage Act. Independent contractors, on the other hand, are your 1099 workers. They don't get benefits. There are no deductions, no withholding requirements, and they're not covered by wage and hour laws. Next slide, please. In Massachusetts, the classification of a worker as an independent contractor is determined based on what's called the three-pronged or ABC test, which has been in place since 1990, and it's codified in the statute that you see on the slide before you. As the test as the title would indicate, there are 3 prongs. All of those prongs have to be met in order to classify someone legally as an independent contractor. But I'll go through them one by one. The first prong is freedom from control and direction in performance of duties. It's important to note that this is about actual control and direction of the worker, not whether you as an employer or a business have the ability to do so, but whether it occurs in practice. The Attorney General's office has provided an example of an independent contractor will complete a job using his or her own approach with little direction and dictating the hours that he or she will work on the job. The second prong is performing service outside the usual course of the employee's business, of the employer's business. The question for this prong is whether the worker is performing services that are part of an independent, separate, and distinct business from what the employer does. If yes, that worker will satisfy this prong, and you can move to the third. If no, they're going to be considered an employee. And finally, the third prong, which is being customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the services that are being performed. To satisfy this prong, the worker has to be capable of performing the service to anyone that wishes to avail themselves of that service in the commercial marketplace, as opposed to going back to the same business time and time again to perform that same service. So think about someone who kind of runs their own business and comes in to perform a service for you from time to time. An employer's belief that the worker should be an independent contractor has no bearing on whether the worker is actually an independent contractor. This analysis is very fact-specific. It can differ from circumstance to circumstance. And it's important to note also that just because your agreements are titled independent contractor agreement, or you refer to a worker in an agreement as an independent contractor, that doesn't necessarily make them an independent contractor. You must meet every one of these prongs. Next slide, please. So now that we've talked about the test, why does this distinction actually matter? The biggest reason is that by virtue of the employment relationship, employers have legal obligations to not only their employees, but the federal and state government where they operate, or that covers where they operate. I've talked about some of them, and some of them are covered here on this slide, but minimum wage and overtime requirements for employees, benefits that you can give employees, tax payments, unemployment, workers' compensation, all of those are obligations that must be fulfilled if there's an employment relationship. And one of the other reasons why this classification distinction between them matters is something that's talked often at the federal level, which is the potential to create an unfair competitive advantage in the marketplace. If a business is constantly misclassifying workers as independent contractors, they're not paying out things like minimum wage and overtime. They're not giving benefits, and they're not paying into the federal and state systems that they would normally have to, which can give them an additional amount of capital or money that they can spend elsewhere, whereas businesses that do abide by their obligations won't have that, putting them at a disadvantage comparatively. Next slide, please. These reasons for why the distinction and the classification is important lead to substantial penalties across a variety of different statutes in Massachusetts, some of which I've laid out here and on the slide that's going to follow. And I just want to highlight a couple of them. The independent contractor statute, which sets out the 3 prongs, carries civil and criminal penalties for violations and possible debarment, meaning that if you're a business that seeks to bid on public contracts, you can be prevented from doing so if you're found to violate the statute. And if you violate the statute, the independent contractor statute, those effects can trickle down into the Wage Act and the minimum wage law and overtime law. Because if you fail to classify someone as an employee that should be, you're not paying them what they should be paid under the Wage Act or the other 2 laws that I just mentioned. Those laws carry treble damages for violations and attorney's fees and costs if you have to go into a proceeding, a legal proceeding where that law is enforced. Next slide, please. Another very important thing to note is if one of the agencies responsible for any of the things that I've talked about here today, be it unemployment, taxation, the Department of Revenue and IRS is highlighted there, or the Insurance Bureau for workers' compensation, get a whiff that workers are being misclassified, they can come into your offices, pour over your records, and assess you for every violation they find, which carries obviously a hefty price tag and a potential PR nightmare if information about that gets out and becomes public. Next slide, please. So briefly, I want to run through a couple of examples of the everyday types of scenarios where you'll see the 3-prong test in action. This first example involves a hotel that hires a receptionist to assist them during the busy summer seasons. That receptionist will come to work every day, and the hotel owner instructs them on what needs to be done and how to do it. And at the end of the summer season, the hotel owner makes a decision. Do I rehire this person for next year, or do I, go to somebody else? Even though this is a seasonal worker, which some of you in attendance today may be familiar with, this is an employment relationship. It fails on the very first prong of the independent contractor analysis, the freedom from direction and control. As you can see here, the hotel owner is telling the worker what to do and does make a decision whether or not to rehire or terminate them for the following year. Because they fail on the first prong, it's not even necessary to go to prongs 2 and 3. Next slide, please. The second example, you own and operate a staffing agency. As part of your business, clients come to you and request temporary placements, and you go out and solicit workers to fill those spots. The client is responsible for assigning those workers tasks and responsibilities once they're placed, but you make the determination about whether to fire those workers. This is also an employment relationship, even though you have a third party that's determining what to do on a daily basis. And that's because, again, it fails on the very first prong, freedom from direction and control. Here, you, the owner of the staffing agency, have direction over whether to terminate or maintain the hiring of this individual. So again, you don't need to go to prongs 2 and 3. Next slide, please. The final example, you own a successful chain of retail stores. A leak pops up in one of your bathrooms and you bring in an outside plumber to fix it. That plumber brings their tools, they make the decisions about how to fix it, and then they go on their merry way when they're done with the work. This is the quintessential example of an independent contractor. This is someone that is free from the direction and control of you, the retail store. They're doing their own work. They decide how it gets done, how long it's going to take them. They bring their own tools. They're independently engaged in a separate practice that is not retail. It's plumbing in this instance. And so they meet all 3 prongs and they would be classified as an independent contractor. Next slide, please. One last thing I want to touch on before I pass it off to the next presenter is a recent change that you may have heard about at the federal level, which is this U.S. Department of Labor independent contractor rule. You don't really need to know much about it. The Massachusetts 3-prong test is stricter than what may be coming down the pipeline. And so you should continue to employ the 3-prong test that we've talked about here today. But if you have any questions about whether or not this upcoming federal change plays a role, feel free to reach out to us, contact your lawyers. So with that, I will hand it off to Tamsin, who will talk about non-competes.
Thank you, Taylor. Good afternoon, everyone. I'm delighted to have the opportunity to talk to you about non-competes right now, because you may have been reading in newspapers, online, wherever you get your news, that there's a lot going on with respect to non-competes. And specifically with respect to potentially banning non-competes. And this is coming out of various federal agencies. Okay, first slide, please. So what's going on? Lots of recent developments, current developments. Is this the end of non-competes? First of all, Federal Trade Commission in January of this year proposed rules banning non-competes altogether as a form of unfair competition. The rules are now in comment period. Feedback is required, and folks expect that the process with respect to the FTC rulemaking will conclude in April of 2024. So stay tuned on that. I'm happy to predict that it's very unlikely that we are going to have an across-the-board ban on all non-competes. Further, there's a lot of question as to the scope of the authority of the Federal Trade Commission in this regard. In addition, just recently, on May 31st, 2023, General Counsel of the National Labor Relations Board issued a memo opining that certain non-competes are unlawful under the National Labor Relations Act. Specifically, her view, which she's recommending that the NLRB enforce, is that overly broad non-competes are unenforceable with respect to your rank and file employees. So that would typically be your non-exempt employees, your lower level employees. Her view is that the non-compete restricts the abilities of employees to engage in concerted activity, specifically to address or complain about terms and conditions of employment, potentially address or engage in activity toward union organizing, and it limits their ability to move on to other jobs or to resign. The idea being that because the employee has signed a non-compete, their opportunities are limited. Because they've signed a non-compete, they would be fearful of engaging in complaints or union organizing because they'd be fearful of termination, after which they'd be bound by a non-compete and perhaps unable or limited in their ability to earn a living and get another job. Interestingly, in a footnote in this opinion or memorandum by the General Counsel of the National Labor Relations Board, she references an old case from 1944 in which there's discussion of certain restrictions for employees being akin to slavery. That this is forced labor. I think it's fascinating that these arguments are now in circulation. I mean, non-competes clearly are in disfavor in many circles. So the forced labor argument essentially revolves around the notion that binding employees to non-competes is a violation of their freedom of employment under the Constitution, and also under certain laws, including human trafficking laws that were intended to prevent human trafficking, specifically forced labor laws. So this is what's percolating. My answer to the question, is this the end for non-competes, is not so fast. And specifically, I point to the Massachusetts Non-Compete Act, which I think is a very intelligent act, strikes a very good balance, and addresses a lot of these issues and concerns, and may in fact turn out to be a model for other states and federal agencies to strike a balance with respect to the proper, appropriate use of non-competes. Next slide, please. So what does the Massachusetts Non-Competition Agreement Act cover? It covers non-compete agreements that were entered into with Massachusetts employees who are Massachusetts residents starting on October 1st, 2018. It does not apply retroactively to employment agreements that include non-competes prior to October 1st, 2018. It does not apply to non-competes that might be in severance agreements. This specifically relates to non-competes that are contained in employment agreements that are that are enforceable or that are active through the period of employment itself. Next slide, please. So what is a non-competition agreement under the Act specifically? It's an agreement that provides the employee will not engage in certain specified activities competitive with the employer after the employment relationship has ended. And this Act also applies to independent contractors with non-competes. Next slide, please. What are the minimum requirements for enforceability? Again, this is current law. You need to know this. If your non-competes are non-compliant, let us know. Let's rework them and put appropriate non-competes that are compliant in place for you. There needs to be a signed written agreement. You need to provide the agreement by the earlier of the offer of employment or 10 business days before employment commences. If you're giving the non-compete or asking the employee to sign the non-compete after commencement of employment, you need to give them 10 days notice and fair and reasonable compensation consideration in exchange for their entering into the non-compete with your business. Next slide, please. So here are the real substantive guts of this act, of our current non-compete law in Massachusetts, which, as I mentioned before, I think really address a lot of the concerns about overreaching, overburdensome non-competition agreements. Number one, very, very importantly, the agreement must be no broader than necessary to protect trade secrets, confidential information, and goodwill. In other words, it must be narrowly tailored to legitimately protect the company's employment, business interests. And oftentimes you see non-competes that are not so narrowly tailored, that are very general, which do not comply with our act. The restricted period post-employment must not exceed 12 months. The restriction must be reasonable in scope, both in geographical scope and with respect to the scope of the activities that are actually proscribed or prohibited under the non-compete. And there needs to be fair and appropriate consideration or compensation for the non-compete. Specifically, the Act provides for what's called garden leave or other mutually agreed upon compensation. And in practice, as I see it, in my practice since 2018, it appears that employers are generally complying with the Act by providing 50% of the highest salary over the past 2 years prior to termination. And that needs to be prorated at 50% over the full duration of the non-compete period post-employment. So as you can see, this Act does a good job of making sure that the non-compete is not overly burdensome, that it is reasonable in scope, geographical scope, and duration, and that consideration is provided. So there is compensation for this promise not to compete for a given period of time. Next slide, please. And in addition, as far as limiting non-competes and their applicability, the statute is clear that non-exempt employees, again, your rank and file employees, may not be subject to non-competes. They are unenforceable against those folks. They're also unenforceable against undergraduate or graduate students who work short-term or in internship relationship with the company. They are unenforceable against anyone who's age 18 or younger. And very importantly, they are unenforceable when someone is terminated without cause or laid off. Prior to this Act, non-competes were enforceable post-employment, regardless of the reason for termination. Now, if you terminate someone without cause, or you lay them off as part of, say, a reorg or a restructuring, you cannot enforce the non-compete against them. So my answer to whether we've seen non-competes come and go at this point is no, I don't think that non-competes are going to be banned, but I do think that the kinds of restrictions we're seeing in the Massachusetts law will be a model across the country. So that's my prediction. And I now would like to pass the baton to Michelle, who's going to talk about the Pregnant Workers Fairness Act.
Thank you, Tamsin. I will be covering the Pregnant Workers Fairness Act. Next, we can go to the first slide, please. So this is a federal law that was passed by Congress late last year, signed by the president, goes into effect later this month, and it provides that employers who have 15 or more employees are required to provide reasonable accommodations to pregnant employees and job applicants who may have temporary mental or physical limitations due to pregnancy, childbirth, or related conditions. The good news for employers here in Massachusetts is that this statute is largely duplicative of the Massachusetts version of this statute that went into effect back in 2018. So hopefully you are already doing a lot of what I am about to cover. And if not, certainly you want to speak with your counsel about bringing your practices up to date so that you're in compliance with both state and now federal law. Next slide, please. So first, I just wanted to provide an overview of medical conditions that can be considered related to pregnancy or childbirth. This is not an exhaustive list, but a good starting point in terms of what to keep in mind if your employees or a job applicant is experiencing one of these conditions. So morning sickness, which obviously can strike at any time of day, not just the morning. So that is something that would need to be accommodated regardless of the hour. Gestational diabetes, pregnancy-induced hypertension, pregnancy-related carpal tunnel syndrome, sciatica, lactation or the need to express breast milk, physical injuries from childbirth, miscarriage, recovery from an abortion, or postpartum depression. So again, this is not a list of the only conditions that would need to be accommodated, but a starting point in terms of what a pregnant employee or applicant may be experiencing and would need to be accommodated under the statute. Next slide, please. So what is an accommodation? Under the federal law is using the same definitions that we're all familiar with from the Americans with Disabilities Act and the Massachusetts anti-discrimination statute. So this should be familiar to everyone. A reasonable accommodation is a modification or adjustment to a job, the work environment, or the way things are typically done during the hiring process. This must be provided unless the specific reasonable accommodation would cause a significant difficulty or expense, which is known as an undue hardship. And again, obviously this is a new statute. There's been no enforcement or case law developed around this, but we expect that courts and the EEOC will be using the same standards that have been in place related to the existing disability statutes. Next slide, please. So just some examples of reasonable accommodations. Obviously, the specific accommodation that's required will depend on the pregnancy-related condition that the employee is experiencing. So you really want to have a dialogue with the person about what they need and how you can meet that. Some of this is relatively easy to accommodate in terms of providing things like longer break periods or more frequent breaks for use of the restroom or meals or rest. If you typically require someone to stand for a certain job function that they're performing, let them use a chair, drink water, eat snacks, even if that's not typically permissible at the work site. If there's a physical component of the job, giving the person light duty or asking a colleague to assist with lifting something, flexible hours or a shorter schedule to accommodate nausea or medical appointments related to the pregnancy. Working remotely is often a good option as it can eliminate some of the physical difficulties related to a commute or to sitting in an office all day. And then lastly is leave. That is a permissible and reasonable accommodation. And if the employee is requesting that, either paid or unpaid, that should be provided. But importantly, the employer cannot require leave if there is another reasonable accommodation that can be provided. So if the employee is not requesting leave and does not want to go on leave, you should work closely with that person to see whether there's another accommodation that can meet their needs that will allow them to continue coming to work. Next slide. So I just wanted to highlight, like I mentioned earlier, this is largely the same as the Massachusetts statute. There is one important difference, and it's a little bit rare in that the federal law is actually more protective than the Massachusetts law on this issue. The Massachusetts law requires an accommodation only if the employee can still perform the essential job functions with the accommodation. Under the new federal statute, pregnant employees can be temporarily excused from performing the essential functions of the job. If the inability to perform the function is temporary, the essential function could be performed in the near future, presumably following the conclusion of the pregnancy. And there is no accommodation that could enable the employee to perform that function. Next slide, please. So just to provide an example, if a pregnant woman is working in a warehouse and her duties have always been to lift one heavy box over here and move it over there, she can be excused from that primary requirement of her job of lifting heavy items and accommodated with another task or mechanical assistance with lifting or some other accommodation that means that she is no longer performing the primary requirement of her job. Just wanted to also note that the Massachusetts statute covers employers who have 6 or more employees, while the federal statute covers employers of 15 or more employees. So if you fall within that window, you want to make sure you're compliant with the Massachusetts statute, but you don't necessarily need to comply with the federal law. And with that, I will pass it to Larry.
Thank you, Michelle. So Allison and I are going to talk to you about hybrid and remote work and what the employer's responsibilities are with regard to those, to providing employees to, or allowing employees to do hybrid and remote work. Next slide, please. So generally speaking, remote employees are subject to the laws of the city and state where they're physically located and performing work. And I say generally, and it's just interesting, there was a recent Massachusetts case where an employer had filed a motion to dismiss, claiming that an employee who had made a claim for wages was not a Massachusetts resident and not subject to the Mass Wage Act. The individual lived in Virginia, did work in Virginia, had no customers that he worked for or assisted in Massachusetts, but he did consistently deal with people in Massachusetts, and he occasionally went to the office, sometimes for training, sometimes for other purposes. And the court ruled that they wouldn't dismiss, that there was enough potentially there to find that the Mass Wage Act would apply to that employee, even though they're a resident of Virginia and working there essentially. And part of the reason the court was looking at that is because of the interaction with Massachusetts and Massachusetts' strong public policy to enforce its Wage Act, which, as was mentioned earlier, can provide for an action to be filed by the employee, recovery of attorney's fees and treble damages. So if you have an employee that is going to be working remotely, and particularly in another state, versus if you're located in Massachusetts and somebody wants to move to another state, you need to evaluate, or if you're hiring somebody in another state, you need to evaluate what your tax obligations are. Next slide, please. With regard to that employee in that state. There are payroll tax obligations that may be different, and you may have to be doing your withholdings and making your payments into that state rather than Massachusetts. There are corporate business tax, income tax, gross receipts, sales that could be impacted depending upon what that employee is doing. If they're making sales, delivering goods, that could subject you to those types of tax obligations from a corporate standpoint, having to file returns and pay tax. And then, of course, there's always the lovely penalties and interest if you fail to abide by the state's tax rules. So those are key things for you to look at before you either decide to let people work remotely in another state or even in Massachusetts, and whether or not how you deal with, which I'll be talking about shortly, an employee who wants to move and work remotely. Next slide. So no, go back one. There we go. So one other thing you need to also consider is the applicability of the state's employment laws in which this employee is going to be working remotely. So you've got minimum wage requirements, which may be different than here in Massachusetts. You have overtime pay exemptions that could be different. The information that needs to be provided with regard to payroll, that'd be payroll stub information, deductions that have to be withheld, the frequency that pay has to be made, and when you have to pay an employee upon termination. Massachusetts, there's a difference when the employee is terminated by the employer versus when the employee quits or resigns. And other states may have different policies there as to when payment has to be made. So you got to look at those to make sure that you don't run afoul of those. The other important point is you need to track the hours of your non-exempt employees. And key issue is how are you going to do that? You need a system and a process by which you're going to do that. And you also need to make sure you enforce compliance with that by the employee, because then you can run afoul of overtime laws in that state, as well as the Fair Labor Standard Act, which is the federal statute. Next slide. In addition, for additional states' laws you need to look at is meal and rest break laws. It could be different than Massachusetts that you're familiar with. Laws regarding vacation policies, final payment of wages on termination, I mentioned already. Reimbursement of remote work expenses. In some instances, some states would require you to reimburse certain remote work expenses. In Massachusetts, if there are work-related expenses that are not reimbursed, you can have an employee who is being paid less than minimum wage because they're not being reimbursed for those expenses, which could run you afoul of the wage and hour law in the state or in Massachusetts. So this remote thing could also, all of these issues still relate if the employee is in Massachusetts. Posting and notice requirements you have both in this state and in other states. You have to post those. What is it required? Do you have to give notices and have the employee post them in their home office, or is email sufficient? So you have to look at those. And a lot of times, for example, leave laws require posting of the rights and obligations of the employer, and the rights of the employees need to be posted in a general location where they're accessible and visible to employees. Prohibition on restrictions on non-compete agreements could change from state to state. As Tamsin mentioned, a lot of that's a little bit in flux with the federal things that are going on, but you need to also look at those. Equal pay and pay transparency laws, which were also talked about before, are different from state to state. So you need to understand what those are and how they may impact a remote employee. And then the leave laws can be significantly different between states versus what we have here in Massachusetts. So you need to understand what those are, not only just for notice, but what you provide, the extent you provide, whether they also have, like we have here in Massachusetts, paid medical family leave, where you have to do withholdings from the employee and pay a portion into that program. So we would need to get in compliance with that and do whatever you need to do to register and do the appropriate withholdings. Next slide. Additional employer responsibilities arise, which would be things regarding workers' comp requirements and insurance coverage obligations that you have to have, which could vary from state to state. You have to make sure that your unemployment insurance obligations requirements are met. You may have to register to do business and assign a registered agent in the state where the employee is working remotely. You also have OSHA work at home workplace requirements, which is essentially to provide a safe and healthful working condition. So that doesn't mean you have to go to the employee's home and look at everything and make sure it's okay, but you think you have to have a discussion about what's there, where are they working, and there's other reasons to do that, which I'll talk about in a minute, just to make sure that there is no harmful thing. Are they working in a office or in a garage where there's gas cans around? That might not be the best place to be working, in which case you'd be working with the employee to move to another place at the home. Communication, training, supervision, and discipline is also a challenge because the person's not in the office. Communication usually is a little bit less robust. Training and supervision are also difficult. You have to make a range. You're either doing it like this through Zoom meetings or whatnot. And disciplining an employee is also different versus a face-to-face or a daily interaction. You also have to account for whatever reasonable accommodations you might have to make under the Americans with Disabilities Act, as well as Michelle mentioned, statutes that protect the rights of pregnant women to the extent you have to make reasonable accommodations. Again, you got to evaluate those. You might have to provide certain equipment and things for the remote worker for use in their home, whether it's a desk, chair, could be a standing desk. There could be a number of things, even, starting late and doing different hours, different things like that. And then importantly, privacy and security. And privacy and security, what I mean by that is, what are you doing to protect the confidential information that's being generated by the employee in their work? What are you doing with regard to financial data and employee information that the employee may be having and working with? Security of files and equipment that the employee is using. Cybersecurity issues that might need to be addressed, using a VPN for the employee to access the server for the company, or is it some other form like go to my PC, and what's sufficient? And what does the employee do with the files and the information that you want to keep secure, and how is it kept in the home? Because you have no control over that. You don't have control over what doors he locks or doesn't lock, whether he's locking the office door or not, or she is. So those would be things you might want to discuss and handle with the employee. And data breach procedures. What happens if there's a data breach? What happens if there's one that the employee is involved in or causes or is impacted by because they get scammed, or somebody does some phishing and gains access through them? You'd need to discuss with them what is the procedures if that happens. As soon as they find out, they obviously need to alert the office and take certain steps and measures. Next slide. So things to consider with regard to your remote workers and setting up the arrangements for the remote workers would be to develop your remote work policies. First, you could consider creating blacklist states. And what I mean by that is there are states where you would prohibit employees from working remotely. So whether they're moving to them or not, and that could be because of the requirements to work there remotely and how it impacts the business and the cost to the business, including tax obligations or otherwise. Another thing to consider with a work policy is requiring remote employees to provide notice if they're moving to another state and to obtain permission from the employer to work remotely from that state. There have been many instances where remote workers move and the employer does not find out for 3 or 4 months, which means for those 3 or 4 months, taxes have not been withheld for that state, and they maybe should have. There could be requirements the state should have registered to do business, should be filing taxes, and maybe has not been complying with a number of pregnancy laws, leave laws, overtime laws that have been applicable. So that one is one I would highly recommend that you consider. The next one is requiring employees to record all hours worked. I mentioned that earlier, and that's very important, particularly if they are non-exempt, which means they're able to receive overtime. You should require them and have a system by which they can record their hours worked. So they're punching in, punching out, which can be done through a software program on the computer. And you should require prior approval before any overtime. It would also make sense to define what the normal work hours are. Sometimes people at home tend to work longer. You start earlier, you leave later, you might take a break, and all combined, you could end up with somebody consistently working overtime hours. It also would be helpful to designate a particular area in the home as to where the person is going to work remotely. And part of that would be for the security reasons I mentioned, is how are you going to secure the files, paper files, electronic, and where they're kept in the house, as well as for workers' comp, workplace injuries. If you have an area where they're working and they are injured outside that area, it may give you a basis to contend that that was not a workplace injury. They're in the kitchen making a meal and they get burned. Is that really a workplace injury? And if you're saying, no, the office, down the hall is your workplace, the kitchen is not, then that would give you a basis to argue that that is not a workplace injury. Office equipment, supplies and company property, again, it's security. You also need to track that, set up a process by which it's returned when requested or upon termination. And how are you coordinating getting updates out to remote workers and making sure that that happens, which helps on your cybersecurity and the programs and applications that are being run. You also have to consider what are your processes for onboarding employees and communicating policies as they are revised and changed to make sure they're sent out and the employee receives them and understands them, can abide by them. And then most importantly, you need to apply the policy fairly and uniformly. And what I mean by that is oftentimes you will have employees who want to move and go to another state and work remotely. They're working remotely now. And you say yes. Another employee comes and they ask to do the same thing and you say no. Is there a uniform reason why? Is it because it's a blacklisted state that the second employee was going to? Are you treating different genders differently, treating different races differently? All of that, that's why it's important to do it fairly and uniformly and have a structure in place so that when the issues come up, you're handling them. So that's all I have on my end of the remote work. I'll pass it on to Allison.
So Larry and I are going to talk about hot issues in termination and separation now. And Larry, I believe the first few slides are about the NLRB.
So I will now talk, and Tamsin touched on this a bit with regard to the non-competes. So there were two recent memos that came out from General Counsel. The first one related to the use of confidentiality and non-disparagement provisions arising out of a case that it's called McLaren. It was a hospital that laid off 11 employees. They were union employees and gave severance agreements. And in those agreements, they had severance provisions. And what the board, the decision on the case came out and said was that the confidentiality and non-disparagement provisions violated the National Labor Relations Act. And that the two things, the mere inclusion of them was a violation. And even the proffering of an agreement containing those overbroad provisions was a per se violation. Next slide. The severance agreement at issue in McLaren contained a non-disparagement clause which prohibited statements that could disparage or harm the image of the employer, the parent and affiliates, officers, directors, employees, agents, and representatives. Very broad. The confidentiality clause prohibited disclosing the terms of the agreement to anyone except for a spouse, professional advisor, unless compelled by law. And the agreement also provided for monetary and injunctive sanctions against the employee if they breached the provisions. What the NLRB said is those were all too overbroad. Next slide. Because they violated Section 7 of the NLRA, which protects non-supervisory employees' rights to engage in concerted activity. So what is concerted activity? Tamsin mentioned this earlier. Concerted activity is the right to join a union or assist a union, bargain collectively, work with your co-employees or other employees to address work-related issues, and to speak about those issues. The NLRB has also given other examples of what would be considered rights under Section 7. They would include the ability to quit or threaten to quit your job in order to try to improve your working conditions, or even to be able to work with another person to improve your working conditions. It would include precluding, an employee has a right to engage and discuss with others, sorry, not to engage, an employee has a right to attempt to preclude unfair labor practices and to engage other employees in the effort to do so. For instance, striking or supporting a strike. So this goes beyond just with your own co-employees. They also have a right to discuss terms of severance with former employees, particularly ones who may be deciding whether to accept severance agreements themselves. They also would have a right to communicate and assist other employees with work-related issues where they're trying to improve their work conditions. Next slide. So a non-disparage, so we talked about there's two clauses, right? The confidentiality and the non-disparagement. Well, a non-disparagement clause might be lawful if it includes statements about the employer that are maliciously untrue, such that they are made with knowledge of their falsity or with reckless disregard for their truth or falsity. It's almost a defamation standard there. Beyond that, the NLRB's position is it restricts those Section 7 rights that I just mentioned. There was a comment in the General Counsel's memo that a non-disparagement clause that's limited this way might be okay. Whether you can get one broader and add what's called is a savings clause, where you say in an agreement that nothing in this agreement is intended to restrict your Section 7 rights. It's still unclear as to whether the NLRB would look at that as sufficient, so that you could put in a more typical non-disparagement clause that's been used up through now, and that the savings clause would say, but that doesn't preclude you from exercising all your rights. So that still remains to be seen how that's going to play out. Next slide, please. So the General Counsel's memorandum does provide some guidance with regard to how the decision in McLaren is going to be applied going forward. First, the General Counsel indicated that the severance agreement that contains an overbroad confidentiality or non-disparagement provision would not void the agreement in its entirety. It would certainly determine that the provisions of confidentiality and non-disparagement are not enforceable, but the rest of the agreement would be able to stand to the extent it didn't violate some other laws. The decision is retroactive, so it applies to previously entered severance agreements that may have overbroad confidential and non-disparagement provisions. I mentioned it earlier that even the proffer of a severance agreement containing impermissible terms is subject to a violation. The good thing is violations are subject to a 6-month statute of limitations. So for those of you who have these agreements out there, you may be saying to yourselves, oh, well, it's been much more than 6 months since they signed that agreement. I guess we're okay. Well, not so fast, because what the General Counsel also said is that previously executed severance agreements could still be deemed to be engaging in a violation of the NLRA and would not be time barred by that 6-month statute. And an example would be where the employer is seeking enforcement of the confidentiality and non-disparagement clause in an agreement that was issued more than 6 months ago, or maintaining that it's enforceable even through a letter to the employee cautioning them not to violate it. Next slide. So that leads to the point I want to raise here, which is any of these overbroad restrictions in a communication policy, not just an agreement, can also violate the NLRA if they interfere or tend to interfere with an employee's exercise of their Section 7 rights. You need to be aware that even if an employee signs these agreements with those provisions, that doesn't absolve you. Employees cannot broadly waive their rights under the NLRA. You cannot affect the rights of employees to engage with one another to improve their lot as employees, which could be discussing the terms of that severance agreement. That also includes former employees. They are also entitled to exercise those rights. Other severance provisions that could also be at risk of violating Section 7 is, as we mentioned, the non-compete, non-solicitation clauses, a broad liability release that goes well beyond when you see these releases that say the company and officers, directors, and then all of its subsidiaries and affiliates and their officers and directors Those could clearly be seen as overbroad. Covenants not to sue, meaning we're not going to file a lawsuit. And investigation and cooperation requirements. Oftentimes there are clauses requiring an employee to cooperate in the event of a lawsuit or an investigation, and assist the company. The NLRA has indicated they may look at those also as violating Section 7 rights. If you are going to be continuing with confidentiality and non-disparagement clauses, it's best to tailor them as narrowly as possible. Limit your confidentiality to maintaining confidential the proprietary and trade secrets info of the company. And maybe with regard to a severance agreement, limit the non-disclosure to just the financial terms, the payments that were made or the amount of the payments made to the employee. The general counsel indicated that might, did not say it would, but that it might be acceptable under the NLRA. Essentially, what you have to be careful about is chilling an employee from assisting other employees, communicating with the NLRB, the union, legal forums, media, or even other employees at other companies with regard to work-related conditions. Tamsin touched on this as far as the other memo that the general counsel issued on the non-competes agreements. And again, what the council is looking at there as to whether or not the non-compete violates Section 7 is whether the employee's ability to quit or threaten to quit is impacted. The general counsel expressed that if you know you're subject to a non-compete, you're going to be concerned that you may not be able to get another job for an extended period of time. It therefore limits your ability to change jobs in order to improve your working condition. You may be reticent or feel prohibited from accepting another job because it violates or maybe violating that non-compete. That also would be restricting your ability to change jobs to obtain better working conditions and improve them. And then the other issue is that with regard to non-solicitation agreements, they inhibit your ability to work, to communicate with, talk with, and coordinate with workers about moving to another company as a group. And I'm not talking about if you're a supervisor where you have some fiduciary duty obligations. But if you're an employee and you found a place that works, that you think are better working conditions, better wages, you need to be able to tell your friends and coworkers about it and encourage them to go. That's part of all Section 7. And the non-solicitation clauses would be impacting that. And in the general counsel's view, would violate the National Labor Relations Act. Next slide. So the other thing I want to highlight is the NLRA provides restrictions with regard to non-supervisory employees. So agreements with supervisors are generally outside the scope of the NLRA. The definition of supervisors is there. I'll let you read it. I'm not going to rephrase it to give you an idea of what is meant by a supervisor. But I will caution you that there are situations where a supervisor would be protected by the NLRA. One example would be if you terminated a supervisor because they refused to commit an unfair labor practice on behalf of the company. They would be protected. But generally speaking, and I think this I would add to Tamsin's comment that non-competes are not necessarily going to go away, because oftentimes non-competes are maybe sometimes more important for your supervisory higher level individuals than the lower level. And I think what you're going to see out there in the future is a lot of push to get rid of the non-competes on the more common employees, not the upper management type employees, the people who are really getting the jobs done and doing the work, because they're so restrictive on those individuals. Next slide. So all of what I just talked about is really showing you what the general counsel's position is and its aggressive posture towards employee agreements that could interfere with Section 7, including not just agreements, but other communications. So it's wise to proceed with caution and talk to your attorney if you're implementing new policies or if you're working to separate employees and want to give severance agreements, you should work closely with your counsel. So what are some steps you can do to help? Let's go to the next slide, please. And some of these are somewhat draconian, and I'm not suggesting you have to run out and do these, but I at least want to put them out there for food for thought. And some of this was reflected in the general counsel's memo with regard to the comments on the severance agreements that exist and were signed and issued before the McLaren decision. First is consider remedying the violations. Well, how do you do that? Well, you would advise those employees who sign those agreements that they are null and void, and you're not going to seek to enforce the agreements or pursue penalties or breaches of those unlawful provisions. Now, some people would scratch their head and say, why would I want to do that? I would like them to, even if I can't enforce it, to think, and I'm not going to because of what Larry just told me, I'd like them to think twice before they do it. And I get that point. The reason to do it is it may give you a defense to the extent an employee tries to bring a claim that this was a violation. You can trot out, I gave notice that it's no longer enforceable and I'm not enforcing it. And the general counsel indicated that would be something that would be looked at as a defense to such a claim. The other issue, and to consider doing this remedy, is the liability for prior agreements may not be eliminated by that 6-month statute of limitations. For example, for the reason I gave you before for that example, which is if you're enforcing it or maintaining it, you're sending notices out to employees. Those themselves are further violations, which takes you out to outside the 6 months. So you may be passed on the actual initial proffer of it, but to the extent you're working to enforce, maintain, then you could have a problem. Another thing you can do is to review your current employment agreements and documents and consider carefully what the breadth is of those confidentiality, non-disparagement clauses, and whether you should narrow those and really make them, more. For instance, on the settlement, you just narrow it to, I just don't want him telling you how much I paid you to, for severance. And the other stuff, we let it go. You can evaluate whether any of the restrictions that are in these agreements might conflict with or chill the rights that I talked about, that were Section 7 rights. And then I would encourage you to work with counsel to determine what, if any, changes to make, and try to do the balance of trying to keep the protections you think you need and want without crossing the line and violating the National Labor Relations Act. Okay, I'll turn this on now to Allison for her topic.
Thanks, Larry. So terminating employees with work visas, that termination can become a bit more complicated. Next slide, please. The first and major question I often receive is, does the employee have to depart the US immediately if they're on a work visa that is their sole basis to be in the United States? The answer to that generally and most often is no. There's a 60-day grace period for employees maintaining the most common types of visas. And during those 60 days following the termination date, the employee can do what's listed here in gray: transfer the visa to a new employer, potentially change to a different visa. And then the third bullet point, USCIS actually has an excellent page on its website about options. So I encourage employers to review that if considering terminating an employee on a work visa. Next slide, please. Employer requirements. This is the second most common question I receive. What am I required to do? First, you're required to notify USCIS of the termination of employment, and in some instances, withdraw the work visa. And then certain work visas, H-1B being the most common, the employer is required to pay the reasonable cost of return transportation abroad for the terminated employee. Important to note is this is not required when the employee voluntarily resigns from the employment, and this requirement does not extend to the employee's spouse or children or the other relocation costs of moving their belongings. This is just a one-way ticket for the employee to return to their last country of residence outside of the United States. Next slide, please. And then just best practice is to document the compliance with these requirements. So in writing, that reasonable cost of the return transportation abroad, that I think should be explained in the termination agreement, that this additional payment is to satisfy that requirement, that specific requirement to pay the reasonable cost for the return transportation abroad. That's all I have for you today. Thank you so much. I'm going to hand it off to Dave Rogers with some great updates from the Massachusetts State House.
Great. Thank you, Allison, and thanks for the introduction and greetings to all the attendees. I'm Dave Rogers, and as you heard, in addition to practicing law here at Davis Malm, I serve in the Massachusetts House, now in my 6th term. Before I dive into discussion, I just want to make the point that at any given moment, there are hundreds of ideas circulating in the House, the Senate, and now with our new governor, Maura Healey. So by necessity, I just selected a few potential new laws, bills that are pending that pertain to the workplace. But if there are any that others you hear about reading the paper or talking to friends and you ever want to get in touch, I'm happy to field questions. So the first item I want to talk about is an act relative to transparency in the workplace, pay equity bills. This builds on the Massachusetts Equal Pay Act, which provided equal pay for comparable work and provided that you can't ask about salary history. There are advocates who believe we need to do more. There are 2 companion bills covered on this slide. One will require employers of 100 or more to submit data. It's anonymous, so in terms of protecting your proprietary or confidential business information, it would be anonymous and then aggregated for job titles, ethnicity, gender, and compensation. And the idea is to create a database, showing compensation and practices around the state. And the other bill would require employees to disclose salary ranges. You heard from Michelle just a bit earlier that many states require that. Here in Massachusetts, we don't, but this bill would do that. And some argue not only would it provide employees with better option to negotiate, but also protect employers, because if they're proactively disclosing their compensation and practices salary range, it would be a shield from claim of discrimination later. And those bills are pending and have some momentum. You never know if they'll actually become law, but they're part of a big discussion going on right now. The next slide, please. This legislation is about payment of wages. This is mostly in the construction industry, where it would require the general contractor to essentially enforce payment of wages by all their subcontractors, because the claim, again, the supposed need is that these subcontractors are not always very good about adhering to the Massachusetts payment of wages law. So, and really it's not so much about construction, but about vicarious liability, because if this becomes law, could the concept of vicarious liability, you're liable to make sure others you work with pay wages. So the next slide has to do with minimum wage. And this is just to flag it for you that there are discussions about increasing the minimum wage in our state gradually over time up to $20 an hour by 2027. I reference this not only if you have minimum wage workers, but many economists believe it tends to put upward pressure on wages generally if the minimum wage is rising. So that's a discussion also pending at the State House right now. Next slide, please. This one is about public sector workers and whether they can strike. Many public sector workers cannot under current law in Massachusetts. So this would permit that after 6 months of negotiation with their employers. That's a big topic at the State House. Next slide, please. And the next topic is rideshare workers. And you heard Taylor discuss in some detail the law pertaining to independent contractors. And it's a complicated area of law right now, and particularly when it comes to Uber and Lyft, but this is going to be applicable to independent contractors generally. There is 2 bills, one advanced by Uber and Lyft, that would define network transportation drivers as independent contractors and provide some minimum compensation and benefits. And then the next slide. And on the other hand, you have a competing bill that would allow workers to form a union, would provide that they're employees, not independent contractors. And so this is a big debate. As you may know, there was going to be a ballot question last year about this, but it held off. And in addition, there's litigation. Before she became governor, when she was attorney general, the attorney general's office sued Uber and Lyft, claiming they are currently in violation of the Massachusetts independent contractor law. So there's a lot going on in this area, and I really flag it for you, just for those in human resources and who help manage your workforce, just to have an awareness that this conversation is going on in our state. In the next 1 or 2 years, you may see significant changes, or on the opposite side, it may further cement our current law. And finally, I want to talk about on the next slide, what's called the common start. And this is more, not only so much as an employment law, but to let you know as employers that there's a big discussion going on now about childcare and early education in our state. And we've heard from employers who it's a tight labor market, particularly post-pandemic. For some women, getting back into the workforce has been a challenge. There's a really big discussion in our state about improving childcare options and early education. And so this would redound to the benefit of employers because many believe it will improve the labor market. So that sums up my high-level overview of some of the issues going on. As I said at the outset, happy to field any questions later, and I'll turn this back over to Tamsin for any Q&A. Thank you.
Great, thank you. Thanks, everyone. We've got some amazing questions here, and we have about 5 minutes. So I would ask our presenters to give me very succinct answers, and let's try to power through these questions. So the first one is for Michelle. What should an employer do when a job candidate discloses during the job application process that they have a disability?
Great, I will try to cover this as quickly as I can. The employer needs to accommodate that disability throughout the application and hiring process, as long as they can do so without an undue hardship. A particular accommodation will depend on the disability, but you want to think about, what you can do that's easy to make it work for yourself and for the candidate. So, for example, if the person is visually impaired and you were going to give them a written test, maybe consider giving the test to them orally or allowing them to use screen reader software. Bottom line, any concerns, talk to your counsel.
And another question for you, Michelle. Would you recommend having 2 people perform interviews at all times?
I think that's probably a good best practice. I'm assuming that question is related to concerns about someone claiming that they were asked an improper question in an interview. Obviously, it's not always going to be feasible, but to the extent possible, I think that it's good to have 2 people there so that there can be a second witness to what took place during that conversation.
And perhaps the second person can be the note taker primarily, which would be helpful, I would think.
Yes.
Okay, and Taylor, regarding independent contractor law, when do you expect the new federal rule on independent contractors will go into effect?
So unfortunately, we don't have insight into when this is coming into play. The comment period for it ended at the end of last year. And so it's been about 6 months now and no rule has been put out there. I can only assume the DOL is still taking into account all of the commentary it's gotten, but it should really be any day.
Okay, and another one for you. I see this all the time. What happens if the worker asks the employer to treat them as an independent contractor?
As strange as it would seem, as you mentioned, this happens. Just like it doesn't matter if an employer thinks the individual should be an independent contractor, it doesn't matter if the worker thinks they should be an independent contractor. You should still apply the 3-prong test to determine whether or not, based on the relationship and the details of it, they would fit as an independent contractor.
And, you know, specifically, I totally agree with you. Under the Wage Act, you can't make a special
Right,
contract with
exactly.
a worker. And I think that if they're asking you to treat them as an independent contractor when they're properly classified as an employee, they're asking for an unenforceable special contract.
Right.
And I've seen situations where folks have asked to be treated as an independent contractor, and then the relationship goes sour, and subsequently they sue the employer for having misclassified them, even though they requested, and it is not a defense. Okay, something for Allison. Thank you, Taylor. Following a termination, are employers obligated to inform an employee on a visa of their options to stay in the US?
No, and I would advise not to get into detail about options or potential options. I think every individual situation is specific, especially with regard to visa and immigration history. So I wouldn't go there. Thank you.
Okay, thank you. Well, folks, we have a couple of unanswered questions here, but we'll be sure to get back to any individuals who identify themselves in asking these questions and address your questions directly. I want to be mindful of everyone's time, so we're going to wrap up. And on behalf of the presenters, thank you all for attending. We appreciate everyone taking the time out of your day. We hope this information was helpful for you and helps you in your day-to-day experiences in the workplace. For those of you who have additional questions, please feel free to reach out to any of us, and we'd be happy to get back to you promptly. Enjoy the rest of your day, and thank you again.